A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. Glad you're with me on the program today. We're going to be talking with Chuck Michel, Second Amendment attorney, head of the California Rifle and Pistol Association, about the huge lawsuit filed this week against California Attorney General Rob Bonta. Can't leave him out. But also the Los Angeles County Sheriff's Department, as well as the chief of police in Verne, California. This lawsuit taking on some of the post-Bruin restrictions on concealed carry, not in terms of the sensitive places. We've already got a lawsuit filed. That's May versus Bonta. Now, this is actually regarding the process of acquiring a concealed carry license and all of the barriers that both the state of California and local jurisdictions like Los Angeles County and say in Verne, California, have put in the way of people who want to exercise their right to keep and bear arms, whether it's the 4 figures that it's going to cost you to apply for a carry license in Verne, or the 18 months you're going to have to wait before you get approved or denied in Los Angeles County, to the fact that if you don't live in California, you can't carry in California because they don't recognize any out-of-state permits. They don't issue permits to non-residents. So your right to keep and bear arms disappears if you live in one of the 49 other states as soon as you cross the state line. One of the plaintiffs in this case, a Floridian who travels to California quite a bit, would like to be able to exercise his right to bear arms when he's in the state, but is absolutely unable to do so without breaking the law. Again, we're going to talk with Chuck Michel about this hugely important case coming up here in just a moment. Before we do, though, let's talk about this for a second. Joe Biden's America. It's crushing us. You've got companies laying off tens of thousands of workers, one after the other. Americans working 2 jobs just to get by. Inflation pushing hardworking families to the brink. Just look at the receipt the next time you go to the grocery store. You'll know exactly what I'm talking about. And a digital dollar could be coming down the pipeline to completely destroy our way of life. The truth is, you need a plan. You know it and I know it. And that is why you should call Goldco. So you can diversify your savings and investments with gold and silver before things get worse. They're a 6-time Inc. 5000 winner, 2022 Company of the Year, with thousands of 5-star reviews. And they help people like you and me place over $1 billion in gold and silver. They're offering up to $10,000 in free silver while supplies last. And if you call them today, qualified callers will get a free Ronald Reagan half-ounce silver coin. So don't wait. Call Goldco at 855-412-3806 today. That's 855-412-3806. And now let's get to our conversation with California Rifle and Pistol Association head and Second Amendment attorney extraordinaire Chuck Michel, talking about the latest attempt to claw back our right to keep and bear arms out there in California. Chuck, appreciate you carving out a couple of minutes from your very busy schedule to talk with us today.
Always a pleasure, Cam. Happy to come on your show whenever you'll have me.
And it is always a pleasure to talk about the lawsuits that you're filing, because this is really, again, I mean, you talk about the CCW Reckoning project that California Rifle and Pistol Association is engaged in, and you all are clawing back this fundamental right, lawsuit after lawsuit, if that's what it's going to take. And this is a hugely important case, right? We were just talking before we started this interview. We've got May versus Bonta. Now that's taking on the post-Bruin carry bills, right? The sensitive places and those types of restrictions. This new lawsuit, CRPA versus LA Sheriff's Department, this is taking on, before you even get your concealed carry license, right? This lawsuit is challenging all of the barriers that the state of California and these local governments are erecting between residents and non-residents and their Second Amendment right to bear arms.
Well, there is a non-residency claim in there.
Mm-hmm.
The reason that we had to do this, after Bruin came down, even before Bruin came down, remember the Peruta case? CRPA had the Peruta case. We won in the 3-judge panel. They struck down the good cause requirement. They went en banc. They overturned it. Supreme Court didn't take it. So the state of the law before Bruin in California on CCWs was you can have the good cause requirement. But the ruling in that 3-judge panel, so it wasn't mandatory. It wasn't a compelling court order, but it was very persuasive. And so a lot of conservative thinking sheriffs and police chiefs read that and changed their policy and started issuing CCWs. So there was a lot of counties, particularly Northern California, and then even Orange County flipped, that became basically shall issue. So there were more permits coming out in California than ever before, thanks to CRPA's efforts even before Bruin. Then when Bruin came down, we immediately saw the writing on the wall. We know the kind of games these issuing agencies play. And we could even see like Attorney General Bonta sent out an email saying you can't require good cause anymore, but you can jack up the good moral character thing and use that as your excuse, essentially. But it's more pragmatic in LA County. First of all, LA County is the biggest county, most populated county in the state. So if we get CCWs being issued there, we're probably going to see those numbers rise quickly of the gross number of CCWs in the state of California. And they were taking too long. They take up to 1.5 years to process these applications. I wouldn't say it's necessarily philosophical. I mean, I'm sure there's been some resistance, but I think the sheriff has bigger fish to fry. This particular sheriff, I don't think he cares if people get a CCW, but he's kind of at war with the county board of supervisors over his budget. You know, they have the whole defund the police, all that baloney.
Right.
And so he doesn't have a lot of money. So he can't put as much staff towards processing permit applications. But we're like, that's not our problem. The state is the one who who's forced this licensing scheme to be in place. You want to avoid your administrative overhead? Go constitutional carry. You know what I mean? Or streamline the process, or extend that. In California, you still got to get renewed every 2 years. Extend that to 5, like most states do. So they have a lot of barriers to getting the permit. You got to go through these time-consuming hoops, psychological exams and stuff like that. And then it takes the clerical staff at the sheriff's department a long time to process the applications. Now they've sped it up, but it still takes a year. Even the state law in California says you can't take more than 120 days. It used to be 90. They just changed it. Now that's probably too long too.
Yeah.
But for now, we can at least say to the court, look, the state law says you got to do it in 120 days. They're taking a year. They have to allocate more resources to processing these permit applications. And that may wind up being an issue where the sheriff can use this lawsuit as something to go to the board of supervisors and say, you got to fund this. And if that happens, that's a win. As long as they're processing those applications and not throwing all kinds of unconstitutional, subjective hoops in the way.
Right.
Now, the other part of this was Laverne, the city of Laverne, is charging $1,000 for a CCW processing for the process. That's just no one. You can't do that. That price is. There's too many people who don't have $1,000 to throw towards a permit that you got to renew every 2 years.
Right.
You know what I mean? This is not CCW is not for the rich. Okay. This is not a classist thing. Everybody gets one, provided they're not, a violent felon or something. So the Laverne is sued too, because they're charging too much. And the gambit that the sort of the racket that they're running out here is these jurisdictions are turning to private processing companies like My CCW or Permitium. They're hiring these companies to process some parts of the application. And then rather than internalizing that administrative cost, they pass it through to the applicant. Well, no, you can't do that either. You can't like get around the internal government processing thing by outsourcing it to a vendor and then charging the applicant the cost that you have to pay the vendor. No, you eat those costs. It's the state who imposed this licensing scheme. It's the state's problem to pay for it. This is like a parade permit or a protest permit or anything. You can't charge $1,000 to go have a protest. It's not, you're pricing people out of the market. I think that's part of that is intentional in some of these jurisdictions. So we challenge that too. So it takes too long, costs too much. And then the DOJ drags their feet on background checks. They're not processing background checks fast enough either. So we're suing them to speed that process up. And then last but not least, if you don't live in California, you can't get a California license, a CCW, and your license from whatever other state you're in is not valid in California. So your right to keep and bear arms doesn't end because you drive from Arizona to California and cross a state line. So we're suing over out-of-state permitting and respecting other states' permits. So it's a pretty good, conglomeration of of different claims, and they should resolve. The process has become the new battleground. You can't require a good cause, but what can you require exactly?
Mm-hmm.
And so we've got SB2 challenging the sensitive places over designation, and now we've got the LA sheriff case that should speed up the process and keep down the price.
And both of these cases, I think, have national implications beyond California. New York, I think, is the only other state that I'm aware of that doesn't recognize anybody else's permits, doesn't allow for a non-resident to acquire a carry license. But we're talking about two of the most populous states in the country, right? So even if, and these states are outliers by their very nature. It's not that, these were outliers in the 19th century. These are outliers today as well. And the fees that you talk about, the 4 figures you have to pay in order to exercise your right to keep your arms. We're seeing games like that being played in blue states in a post-Bruin environment as well. California is not the only one. I think maybe some of the most egregious examples are found in California, right? Because you've got not only these third-party companies, but you've got these psychological exams that many jurisdictions are imposing, right? Where you've got to go and you've got to sit down and take a psychological test. That's being challenged as well, right?
Yep.
But this
subjective tests that Bruin doesn't allow. It's got to be objective criteria.
Yeah, but I want people to understand, like, as bad as it is in California, and as bad as this is for Californians, this lawsuit, I think it has national implications. Wouldn't you agree?
Yeah, absolutely. You got to keep in mind, California didn't come up with this sensitive places law in the mind of Gavin Newsom. None of these guys in Sacramento are sitting there thinking about anything beyond their next press conference and their next election. They're not thinking about, what does Bruin really do and how can we, get around it? They're going to Everytown Law and saying, how can we get around it? Or more likely, Everytown Law is going to them and pushing this agenda. And it's not just CCWs and trying to make those harder to get. It's also semi-auto bans, magazine capacity limitations, prohibited places, prohibited people, unsafe handgun rosters. All of this is a way to, and taxes, excise taxes. All of this is just part of the effort, and it's being coordinated nationally by Everytown to push these new laws. And then when we sue over them, or people in the other groups in the other states sue over them, Everytown Law is there to help them help state attorney generals write the briefs.
Yeah.
So this is not, Bloomberg's money is right there in the game. He's got lawyers from some of the biggest firms in the country, in the world, and they're not dumb. They're pretty friggin' clever, and they can come up with creative ways to try and frustrate what the intention of Bruin. And so we have to keep fighting back and see what happens with Rahimi. Maybe the Supreme Court straightens some things out with that one.
We can hope so. But, you talk about Everytown Law, and not only do you have Everytown Law, which is basically, again, this is their own white shoe law firm, right? Their in-house law firm for gun control. Yep. But now we're starting to see alumna of Everytown Law move on to academia, right? So University of Minnesota Law School, Megan Walsh used to be with Everytown Law. Now she's running the gun violence clinic there. So you've got law students who are working to help Attorney General Keith Ellison file lawsuits. I think Massachusetts, the Attorney General just hired an Everytown Law alumni to work in their Office of Gun Violence Prevention. So, they've got this network that they're building, right, within not just the private sector, but the public sector as well.
Yeah, they've been bivacking. They've been putting plants. They'll fund a position at a city attorney or county counsel's office. They'll fund a position. It's like an endowed chair. They pay for a staffer, and it's a staffer they pick. So that's not new, but it's definitely happening more frequently. But they've been embedding. It's like a freaking Manchurian candidate. They put these influencers
right
in government offices to try and steer the policy the way Everytown Law wants it to go.
Yeah, and then they get judges to complain about, this attorney or this historian. Well, they don't have the right credentials, right? They worked or they supported the Second Amendment. I've seen some very one-sided, rulings where the plaintiff's experts are sort of disregarded, the defendant's experts are, placed on a pedestal. That's probably another topic for another interview. But getting back to CRPA versus LASD. I want to talk for a second. You talk again about the scope of this lawsuit, all of these various provisions that are being challenged. And each of these provisions has a plaintiff with a very compelling story attached, right?
Yes.
So the non-resident, this Florida resident who's a PhD candidate, spends a lot of time in California. Now, why should his rights stop at the state line? You've got an individual, several residents from Laverne who are named plaintiffs, who are on fixed incomes, right? Who, as you say, can't afford $1,000 as an initial application fee or $500 every 2 years in order to exercise a right. How did you find these plaintiffs, or did they find you in some cases?
Well, a little of both. We advertise, we're constantly not advertise, but we put the word out that we're looking for plaintiffs, that it's no cost to those individual plaintiffs. We'll help them vindicate their rights, and people contact us. Other people just come in because they're looking for us to help them with their situation with LA County Sheriff. That's one of the reasons we picked LA County. We probably had 200 people writing in saying, I can't get my permit. It's taking too long. They keep asking for this, that, and the other thing. Help me. And so we try to help those folks as best we can. We can't really help at this point. We're too busy to do individual cases at this point. But if someone comes in and says, they turned me down because of a parking ticket, well, that's not just about that individual. That's about a policy.
Yeah.
So we look at all the people that come in, what their situation is, whether or not their situation is representative of a larger, more problematic policy, and then we'll go after the issuing agency over the policy, not necessarily that individual person, but the way all people similarly situated are being treated by the sheriff's department. So, but they come into us, we reach out to them, and we have been, we've kind of learned that we don't want to get into a big, long, protracted argument over legal standing, over whether the person that we're using as a plaintiff has legal standing to challenge what we're challenging. And so we find the people that have the facts that fit the situation to avoid that argument.
Well, again, you've got some really compelling plaintiffs in this case. I want to ask you about a couple of developments. I was looking at the latest docket for this case and saw yesterday this case was assigned to District Judge Sherilyn Peace Garnett and Magistrate Judge Autumn Spaeth. And there was also a notice to counsel regarding consent to proceed before the United States Magistrate Judge. So tell me about that, Chuck. Where I mean, this is obviously, kind of the legal details here, but this isn't assigned to Judge Benitez, unfortunately.
No.
What does this mean that this is going to proceed before a magistrate judge? Is the magistrate judge going to handle sort of the initial proceedings?
It's not. No, look, this is how all federal cases are processed.
Okay.
Most federal cases are not civil rights cases. So somebody sues somebody for, they got hit by a post office truck, and so they're suing the federal government for breaking their leg. Well, then you could go through the magistrate. Like on a case like that, you probably don't need to go to the United States District Court judge. It's a personal injury case, these lower types of cases. Then you can do that in front of a magistrate. Magistrates also can sometimes referee discovery disputes, like information exchanges disputes. And you can get a preliminary ruling out of a magistrate judge, but then it gets reviewed by the district court judge. Anyway, that's more in the weeds than anybody needs to know, because when it comes to constitutional challenges, we will decline to accept the magistrate. There's no point in mediating. This is not a money damages case, it's debt relief. So we'll be in front of the district court judge. Now, that district court judge is a Biden appointee, but she's a former U.S. attorney, prosecutor. So I'm not exactly sure where she fits on the Second Amendment ideology and what she's going to try and do. Biden appointee is a bad sign, but we'll see. You can't challenge a federal judge. In state court, you get one preemptory challenge. You can knock out the first judge you get and see what you get second. But in federal court, whoever you get, that's who you get. So
okay. Hopefully
she will. Some of this stuff is pretty clear. It's not really, but here's the problem. I say that as the logical person.
Right.
And then the political guy who's been doing this for a long time and seen how courts can twist stuff says, well, you never know. We'll see what kind of creative arguments every town law coaches the California DOJ and the LA County Council to come up with, and whether it's something that she could plausibly buy into and adopt.
Right.
But I mean, when you're taking a year and a half and the state law says 120 days is the max, how do you get around that one?
Absolutely. Listen, I'm with you. I mean, I wrote a piece at Bearing Arms yesterday for our VIP members talking about how is Rob Bonta going to defend the ban on non-residents being able to carry in California. I tried to game this out. What are the arguments that he could use? What are the arguments he could raise? And I got to tell you, I mean, I'm not an attorney. I was really drawing a blank, and I love the citation. I think it was the Shuttlesworth case that you all cited. And I'm so glad that you referred to a civil rights case, because this is a civil rights issue. And just as, Birmingham, Alabama said, well, you can't demonstrate, you can't have a parade, you can't have a protest unless we give you a permit, which we're not going to give you. The Supreme Court said, yeah, you can't do that. You have the same situation here. And so I'm with you, like from a logical perspective. I don't know how you defend the indefensible. I'm sure every town law is going to try to come up with some way to argue that, well, carry licenses are different than marriage licenses or driver's licenses, even though there's a right that's implicated here. The state has the ability to determine who gets to do that. And if they decide that, see, even then the logic falls apart. Fine. Okay. The state wants to decide who gets to carry, but you can't just say that the residents of all 49 other states aren't smart enough or trained enough, or they're unlawful or they're prohibited.
They're prohibited from possessing firearms in public in California. Every person with a CCW, at least in any other state, can't carry here.
Yeah,
no, that's not. So California never wanted people to be able to get a license, non-residents to get a license. They never wanted non-residents to be able to carry here, which is why they refused to accept out-of-state CCWs. But now they have no choice. I mean, you're absolutely right. Basically, you're creating a prohibited class of people. Everybody from the other 49 states who has a permit in that state, they are still prohibited in California. So this is in a sense, it's a prohibited person case. Can you classify all those people as ineligible to carry a firearm? So we're saying, no, you have to accept their out-of-state permit. Now, if we get a court to go along with that, I guarantee you the legislature will be up in Sacramento coming up with some non-resident permit process, which they will try and bog down, just like they're trying to bog down the resident permit process. But at least that'll be a step in the right direction. At least it won't be a full ban on non-residents possessing or carrying in California.
Yeah. And again, implications for states like New York as well. So we've still got a couple of weeks, right, before the state and the other defendants have the deadline to respond?
Well, to respond to the complaint, but we're going to be filing for an injunction, and then they're going to have to. That's going to step things up. So,
okay.
We don't. The typical process is you file a complaint. The lawsuit is the complaint. They have to file some kind of responsive pleadings within 30 days. Then you go into this fact-finding discovery process, which can take years. And so we short circuit all that, and pretty much every group is doing the same. When you file a Second Amendment challenge, if there's been a Second Amendment violation, that is a per se grounds for a preliminary injunction. And so we move for a preliminary injunction right away. So we'll get a hearing on a preliminary injunction within 3 weeks or so. There'll be a briefing schedule that has to be set up, and then we'll have a hearing on a preliminary injunction. So it accelerates the entire process. So we're probably a month from having that hearing, and who knows how long after that before we get a ruling from the judge. But at least that will be, we will telegraph. And in many of these cases, that's as far as you go. I mean, when the state loses on a preliminary injunction, it's called an interlocutory appeal. The case is not final yet because there's no judgment. There's just this ruling on the preliminary injunction. You can appeal that. And so that's where we are in the Ninth Circuit on most of these cases. The state lost on the injunction phase, and now they're appealing the loss on the injunction. Then it'll go back down to the trial court to get a final judgment after we go through the rest of the process.
Yeah. Where is and I'm going to call it a companion case because I think it is the other side of the same carry coin, May versus Bonta. Where are things with May versus Bonta right now?
Well, that's our case. That's the SB2.
Right.
And it's similar. That's a sensitive places case. There was a hearing scheduled for yesterday. the court postponed the hearing on its own motion because there's another case that makes similar claims, and it consolidated the cases and moved the hearing date. I think it's till the 12th, but I'm not quite sure. It's anyway, the hearing has been postponed. So we're briefed on the injunction.
Okay.
Now the court has to have oral argument. They'll have a hearing, an evidentiary hearing, a little mini trial, and decide what their ruling is going to be.
And when does SB2's restrictions kick in? January 1st?
January 1st. January 1st. So we're looking for something before then.
All right. Well,
we filed that case before Newsom even signed the law.
Right.
He was going to sign it. So we filed it to get that ball rolling as fast as we possibly could. But he didn't sign it until the end of September.
Yeah.
So, we couldn't really file it a whole lot sooner and make it go in a whole lot faster. We had to wait until it was actually a law.
Well, yeah, because otherwise then you get tossed out because you don't have standing because it's not yet a law. So, I mean, there are all these intricate details. We saw that happen with, I think, the Antonia case in New York. The judge said, well, this first case, you're a little premature in filing. They went back, they refiled, and now the case is going on. But
right.
Yeah, there is I don't know how you keep track of this stuff. I have a difficult time keeping track of all the cases that you all are involved in. But you were doing...
Not just keeping track, but trying to read the briefs. I got a stack. I have a stack about 8 inches high of briefs that I'm trying to get to read and keep up to speed on what's going on. But there's hundreds of cases going on across the country now.
I know.
And there's probably 50 just from like the big 2A groups. And then who knows how many groups, like the Rahimi case was a federal public defender case.
Right.
So, and this is where some of this 2A stuff really, it's a little sticky because they're raising it as a defense in a criminal prosecution. And that is not the ideal place to be making constitutional arguments, generally speaking, because you typically have an unsympathetic defendant like Rahimi.
Right. Or Mr. Miller in the 1930s, for that matter. Right.
Yeah. So, but who knows how many of those cases there are? Bottom line is there's a ton of 2A cases in courts all across the country. We're trying to keep them coordinated as best we can between the CRPA bringing suits in California, the Second Amendment Law Center doing amicus campaigns in all the significant cases across the country. We're trying to keep our hands and our mind in all these cases to keep track on what kind of legal precedent comes out of them and how we can use that in other places. It's not just this case is legal precedent nationally. Every one of these cases, like SB2, there's been, I think, 5 jurisdictions that said you can't have all these places designated as sensitive because California is a year behind on this. Remember, California couldn't get it passed last year. A bunch of other states passed it, even though California didn't. And so there's been challenges to those, basically the same as SB2 in another state, and they're pretty much all losing. So you can't say every park is a sensitive place, every parking lot is a sensitive place,
right?
So I expect that that's going to make it easy for that judge to issue our injunction because other courts already have. So it's not like he's got to go out too far on a limb.
Yeah. All right. Well, listen, again, I appreciate you taking a few minutes today. I know that we'll let you get back to that stack of briefs behind you, but I will be calling on you in the very near future to join us once again, because there is always something new to talk about out there in California. And Chuck, thank you for your time today. Thank you for everything you and your associates are doing. Really, it is just, I thought of this yesterday, you do bear a passing resemblance to Mr. Incredible or Captain Incredible, whoever that guy is from The Incredibles. I thought someone needs to do a Pixar style picture of your entire team at Michel and Associates with all of you as superheroes, because you really are Second Amendment superheroes. And so thank you again for all the work that you and your associates are doing.
Well, I don't think my chest is as big as Mr. Incredible. My waist is certainly not as tiny as his, but I appreciate that. And Kim, you without folks like you getting the word out because of the censorship in the mainstream media about this and all the issues and the subtleties, this gets lost, on most of these reporters. The only way to get it out is through influencers and journalists like you. And so, thank you for keeping people informed. This is how people realize that we are in a historic time. This really is. We're making legal history here.
Yeah.
This is like, the civil rights jurisprudence, the First Amendment jurisprudence, all these things. We are in the middle of making history, and anybody who supports these efforts is part of history. So we appreciate you, and we appreciate folks who support us.
Well, thank you for the kind words, Chuck. We'll talk again very soon, and thanks for joining us here on Bearing Arms Cam and Company.
Okay, till next time, Cam. Thanks.
Many thanks to Chuck, not only for joining us on the program today, carving out a couple minutes from a very busy schedule, but again, also for the incredible job that he and his associates have done in putting this lawsuit together. I am so looking forward to seeing. I'm always curious to see how the defendants in these cases are going to respond when we're talking about such egregious violations of our constitutional rights. I'm really curious to see how Attorney General Rob Bonta is going to try to defend this complete and utter prohibition on bearing arms if you're not a California resident. I think all of these measures are going to be really difficult to explain away, right? The 18-month waiting period, the $1,000 or more that it'll cost you to apply for a concealed carry license, the mandatory psychological screenings established by some jurisdictions. None of those things, as Chuck said, have the historical analogs that would be necessary to keep them in place. But yeah, I want to see the reasoning deployed in defense of the indefensible. And I guess we'll get to see that defense coming up in a few weeks. Right now, let's turn our attention to today's Armed Citizen story, our good deed of the day, and our recidivist report. We'll start there with a case out of Texas. A Beaumont man pleading guilty to a 2021 shooting that left 4 people wounded and walking away with probation as a result. I mean, this is just kind of crazy. 25-year-old Jose Francisco Ortiz Roca of Beaumont pleaded guilty on Monday before Judge John Stevens in Jefferson County Criminal District Court to 4 charges of aggravated assault. He was indicted on these charges 2 years ago after he was arrested in connection with a shooting at a club parking lot. 4 people were wounded in the shooting. Happened just after 3 a.m. on April 4th, 2021. Each of the 4 charges, a first-degree felony, punishable by 5 to 99 years in prison if he'd been found guilty at trial. But instead, he takes this plea deal, and he's sentenced to 10 years probation on each charge. So no prison time whatsoever. I thought, okay, well, maybe there was some sort of self-defense allegation here, some sort of, argument that could have been made that, look, he was not the initial aggressor. He was acting in defense. Maybe these people, were innocent bystanders, but got wounded. It doesn't really sound like that. According to multiple witnesses, they said that Ortiz Rocha was driving a maroon GMC Sierra. So he's behind the wheel of a vehicle. He's in this parking lot. He could drive away, right? Instead, he fired into a crowded parking lot through the driver's window. Witnesses told police that there were, quote, numerous disturbances in the parking lot that led to the shooting. So it may very well have been that Ortiz Rocha was not the initial aggressor, that there were other things going on. But given that he was behind the wheel of a car, one would think he could have exited that parking lot or at least ducked down. He apparently was the only person charged with firing shots in this incident. So it's unclear whether or not there were any other guns involved. And it's also unclear why prosecutors were so intent on offering a deal like this when they had witnesses who would testify that he was the shooter. But for whatever reason, Ortiz Rocha getting a 10-year probationary sentence for 4 violent felony charges. Today's Armed Citizen story, also from the Lone Star State, quite a bit of ways away from Beaumont, in West Texas, Amarillo, where police say a homeowner shot and killed an intruder who kicked in his door. This was just before midnight on Monday. Police called to a home in the 800 block of North Nelson Street on reports of shots fired. When they arrived, they found 38-year-old Jose Roberto Gutierrez Torres in the driveway of the home, suffering from a gunshot wound. He passed away from his injuries. The homicide unit determined that Gutierrez Torres had tried to break into a home by kicking in the front door. Police said the homeowner, in an act of self-defense, shot Gutierrez Torres. The homeowner interviewed by homicide detectives before he was released. Again, police say that this was an act of self-defense. They might refer this case to the local DA or a grand jury, but homeowner not arrested. Again, somebody kicks in your front door in the middle of the night. They're not there to sell you Girl Scout cookies, right? You have a right to protect yourself and the people inside that home. Finally today, our good deed of the day, in the right place at the right time, willing and able to do the right thing. A teenager, not his first day on the job, but his fourth day on the job, saving a life. Jackson Tehran is his name. He is a busboy at the restaurant Carnivore in the Queen, which is in Downers Grove, Illinois. And while he was at work, again, his fourth day on the job, the teenager noticed that a man in the restaurant was choking. Jackson Tehran says, I noticed a man, he was choking, and I noticed a noise, so I looked over there just to make sure everything was all right. And you could see the guy was really struggling to breathe. He told NBC Chicago that he rushed over there, said, I saw his face was getting red. I asked if he was okay, and he started shaking his head. So that's when Tehran started performing the Heimlich maneuver. Eventually was able to dislodge the obstruction of the man's throat, get him to start breathing again. Tehran said he was taught the Heimlich in 9th grade. He's 15 years old, so not all that long ago. But he also said he watched a lot of 911 shows on Hulu. He said, I don't know how to explain it. I just reacted. I mean, I never thought that watching TV could help you save a life, but I guess depends on what you're learning, right? So Jackson Tehran in the right place at the right time, willing and able to do the right thing to save the life of a stranger there while on the job at Carnivore in the Queen. I like the name of the restaurant, by the way. We thank you, Jackson, for your very, very good deed. Now, that is all the time we've got for you on today's Bearing Arms Cam and Company. We will be back tomorrow with more of the latest Second Amendment news and information. And, of course, we're updating the website constantly throughout the day, whether it's Al Gore comparing social media algorithms to AR-15s or a federal judge in New Mexico further limiting Governor Michelle Lujan Grisham's ban on concealed carry in Albuquerque and Bernalillo County. We are reporting the latest details for you. If you like what you see, I would encourage you to become a VIP or VIP Gold member. All you have to do, go to bearingarms.com/subscribe, use the promo code GUNRIGHTS, and you can get a significant savings on your VIP membership. We're going to give you exclusive content you won't find anywhere else. News stories, analysis. You get the VIP Gold live chats with Hot Airs Ed Morris and myself, as well as other great live chats from the Town Hall Media family. Again, I'd encourage you to check out all that is offered through our VIP and VIP Gold memberships. Just go to bearingarms.com/subscribe. We'll see you back here tomorrow. Until then, be well, be safe, and be free.